Очень хорошо.
It's really good that we have so many young, personable, attractive lawyers. They're interested in property law. You're here seeking property law, property rights. That's great. Anton and myself, we are going to be real friendly. We're going to be real friendly co-facilitators, and please let's have substantive discussion and let's not quarrel. Well, we already have certain agreement with our German colleagues not to argue too much. Well, you know that the civil code and the first part of the civil code is now being updated, and the update is practically over. And if the State Duma and the Federation Council are going to work through the property rights, which means is going to be an open road to start working at the second part, this separate contracts and obligations, and that's why we've been having some real busy discussions regarding property rights, and this part is the most one of those that are really prone to discussion. And the idea was just to broaden the set of property rights that we could be using in our economy and our civil turnover. And practically we have the property right per se and lease. But I would like to have some other proprietary rights, legal form of somebody else's property, using some other types of property rights. Let's discuss matters, let's argue. On the 19th, they had the discussion in the State Duma with the participation of the representatives of entrepreneurs, very reliable companies, and I believe that our business community recognizes the existence of other property rights. This is very useful. At the same time, they told us that they were used to lease already, but nobody is taking the right of lease from them. We're not going to substitute for the lease, no, but we would like them to have the whole range of property rights. So this is what we're doing. And Anton, if you want to say a couple of words, just as an introduction. Good afternoon, distinguished participants of our roundtable. I wanted to say just a couple of words regarding the background situation we have in this real civil law issue, such as the notion of property law, also limited property rights, and this background, it's quite painful. People overreact all the time, and I think that still we are facing this very serious task to provide the guarantee of property rights and we are dealing with this property rights system, and that's why we promote different amendments to the civil code. In the course of 20 years, we had a lot of redistribution and a lot of changes in the system of property relations. And the system of property rights that could be guaranteed, well, we don't have it established yet. And now we have this historic opportunity to somehow have this system and provide reliable guarantees and maintain it. And in response, it suggested that we have somewhat some substitutes, so-called property lease. Well, if we have the property lease and if it's reflected in the civil code in such a way that they would receive the necessary guarantees, well, in this case, it's going to be the limited property rights, such as the right of construction in the property. And when we're talking about property lease, well, if the grandma had the mustache, so she would be a grandpa. But still, they want to have a bearded grandma for some reason. That's how I treat their ideas regarding property lease. And I believe, I am convinced that judicial practice which regarding lease and which made it the property lease because of the division of the titles on the land and the building which is situated. On the one hand, it played a very positive role because it gave the opportunity for investors not to so that investors couldn't be kicked out of the plot of land. Well, that could be the right type of lease. Please, everybody present, pay attention. Because when the lease is over, you demolish everything and you leave. Our judicial practice is quite different. Started providing guarantees, and these guarantees are not are not guarantees because they wanted to give them as such, but that was the logical result. And now they say, let's leave it, let it be, let it exist. I believe that this, this path is not going to lead to anything good, because even the idea regarding the right land ownership that prevail in Anglo-Saxon system in the recent years, after introducing serious changes regarding a right of land use in Britain, it shows that these rights they become actually property rights, and they provided priority first of all to registered right compared with a non-registered right. And if we do it with lease, it's going to become a kind of a property right system. But should we do it? Is it necessary? I'm convinced it's not necessary. We must take the normal system of property rights that corresponds with the needs of our civil turnover, which requires that the property belongs in accordance with the established guaranteed rights. And those are standard rights that they could be terminated only in accordance with the grounds provided by the law. And it seems to me that this is the right kind of approach, and it's going to provide very reliable guarantees of property rights and also real estate rights and so on. Thank you for your attention. Thank you. And now, well, we have the speakers, and our time limits, well, 10, maximum 15 minutes. Please be very careful. Up to 15 minutes, that's maximum. And now, Evgeny Sukhanov, Deputy Chairman, the Presidential Council for Codification and Enhancement of Civil Legislation, head of the chair of civil law of Law Department of Moscow State University. Thank you. Thank you, distinguished colleagues. I believe that now we have the new round of discussions that we already discussed 5 or 7 years ago when we prepared the concept of the development of civil legislation. And people remember that chapter dedicated to property rights. It actually was passed in the State Duma almost unanimously. Nobody complained. They concentrated their attention on legal entities. But then, after they decided to read it after all and realized what was going on, and our business realized what was going on, and that's when everything started. And now we have some hope that maybe by the end of this year we are going to get the new wording of property rights system, and we are actually restoring normal civil law institutions for free market, corporate law. We restored that notion. Now we have corporate relations. Now we have the system of corporations. Is it good? Is it bad? But it does exist. It's great that it does exist. And the same with the so it's the same with the law, and in the code of 1922 we abolished the real estate notion because of nationalization of land, and property rights disappeared as such, and now we try to do something about it. And I have so I have some statements to make. My colleagues might criticize me, but I don't like the name of our session. Why are we talking about something favorable for business? Is business the only participant? Well, like they say, we do everything for the human beings. Yes, and we knew those human beings. We knew their last and first names. But not everything should be done for business. Actually, not just business, but also regular rank-and-file citizens are going to get it. So social servitude, so neighbor rights, and citizens shouldn't be forgotten. We're talking about restoration of general institutions of civil law that are necessary for the whole turnover, not just for business. Secondly, we encountered a strong resistance of the Ministry of Economic Development and major business, although several years ago, we dealt with some of those reservations. Now lease. Colleagues, what happened here with the lease, it's the same. For example, promissory notes are well developed, and if I give a promissory note, I am considered to be just paying the debt. A promissory note is a promise. It's and in some systems, promissory notes are recognized, but it's promissory. It's a promise. And promissory notes are put as authorized capital of corporations, and they still have discussions why shouldn't promissory note be part of the authorized capital. Yes, why not? IOUs and promissory notes, wonderful capital. Why did it happen so? Because in the 90s we didn't have enough cash in the turnover, and the promissory notes are now inflated. We have the courses of promissory notes law, as if we are living in the 19th century. Developed systems, the lease, the code of 1922, with the abolishment of property rights, led towards just lease becoming a property right. I would like to quote a well-known textbook by Shershinevich. This problem is not 100 and it's older than 100 years old, and there is the fight between the legal logic and the interests of the party that keeps the lease. And if the new owner is there, this new owner didn't have any contracts with the party that's leasing this property, and that's why that property can be taken away. But life is against this logical, because mostly we're talking about tenants' rights, and tenants' rights are important because the tenants are part of the society and they must be protected. And that's why the lawmakers by the end of the 19th century, beginning of the 20th century, divided into different groups. French and German law, they supported the lessees, and another party was just on the part of the new owners. But when it's movable property and the owner is the new owner can take this movable property paying the damages. But with real estate we have problems. We can be talking about plots of land, agricultural plots of land, and the French also emphasize that. Or we're talking about the lease of housing. And again, if the owner has the interest of his own, the owner can take that thing at some, and if this lease is registered. And that's why it seemed to me that everything was clear, everything was known. To make some special, to make some special covenants for lease of real estate. And this is just one of the indicators of property rights that are determined by the law. Let's apply it for lease. In the lease contract, I could write about sublease. Maybe not. And the lease, it's not property right, and it's the right of obligations. It doesn't provide you the property right, and it must provide for quiet ownership or quiet use of another of somebody's property. And there is going to be no revolution. Nothing is going to change. But regarding the right to put some construction site on the plot of land, it's highly important right.
The code of year 1922, among the property rights, has preserved two of them. The pledge, which exactly belongs to the property rights, even though we here consider it as a right of obligation. Most lawyers now agree that mortgage is a property right, but the pledge belongs to the right of obligation. It's like cutting a single institution into two halves, going opposite ways. Now, what about the right of the mortgagee? That is property right, no doubt about it. But that was the situation we had back under the Soviet rule. The right of site development is property right, and we are here sticking to the code of 1922. Again, the current situation is not exactly as under classical jurisdictions. When we discuss property rights, we mostly discuss immovable property, and most of that is plot of land. 90% of land in this country is privatized. The right of property allows usage of a third party's land, and a third party's mostly means public. In 9 cases out of 10, land is public property, and a building sitting on it is private property. So there is a gap in the right of ownership between the ownership of land and the ownership of buildings. In other jurisdictions, this is rather an exclusion, but here it's a right. Usufructs and servitudes are targeting relations between two owners. But here we have the state on the one hand and the private owner, the site developer, on the other hand. So in their classical revision, the institutes cannot be used here. In regular jurisdictions, buildings and structures can be transferred to the property, to the ownership of the landowner. Are we going to start another nationalization of the completed buildings? So the draft code says that after the right of site development is exercised and completed, the built property belongs the property of the site developer. Normally, the land is owned by the government in this country. At the same time, let me get back to the issue of correlation between the lease and site development right. Lawyers, not only businesses, are appealed to understand the advantages of right of site development as compared to the right of lease. These are property rights. They secure clear rules for using a third party's property. A third party may become a counter-agent by cession, but the right of property does not depend upon the encumbrances of the property. In regular jurisdiction, and happily hopefully it will happen here, normally site development is conducted with somebody else's money. Very often in this country, the investor and the developer are the same person. I sometimes fail to understand who a developer is, because in the old days we had the contractor and we had the customer. But here we have the contractor, the investor, the developer, all in one. But let's take shared construction. I'm really embarrassed to mention the subject because I believe this is a disgrace of Russian legislation. They put a fence around the plot of land, they collect money from the future apartment owners, and they are promised to get the apartment sold to them in future. What they pay for is pure air. I have 2 more minutes, haven't I? 2 more minutes, I've checked. And this is no good. Any site developer needs a loan, and it's the right to site development that can be used as a collateral to the loan. Back in the 90s, there was Article 79 drafted, and the right of site development becomes the subject of pledge. But I cannot understand how you can possibly pledge the right of lease. when a building is purchased, if there is just one owner of the building and another owner of the land, how can I possibly buy a building? I have to come to terms to the landowner, and that's complicated. Once the right of site development is purchased, and under that right, if the building is also part of it, same as it is in Germany, for example, the situation becomes much more simple. The right of development then becomes complete, because the building cannot be suspended in the air because somebody's right to the land has terminated. What becomes with the building after that? Shall it be knocked down? So, very briefly, there are a lot of advantages, same as in any other land law in any other country. And these advantages are not borrowed, are not just visible and clear from foreign jurisdictions. We are going the way of developing our legal institutes under the conditions of market economy. And I'm firmly convinced that sooner or later we shall have to introduce the adequate property rights and adequate property rights protection. Today they are we consider them as the rights of obligation. We need proper protection of property rights. That's inevitable if we want to go the good way of market economy, if we want to achieve some decent point along this way. We want to support this motion, this development, and we want to adequately formulate the relevant legislation. Thank you. Thank you very much, Dr. Sukhanov. And now I'm happy to grant the floor to Yuri Tolstoy, Professor of Civil Law Department of Law Faculty with St. Petersburg State University, Presidential Advisor on Codification. You are welcome, Professor. I would like to start my presentation with a question. I'm taking advantage of the fact that in this audience, side by side, we have the key drafters of the new civil code. So the question is, what is your draft code, or who is your draft code for? Is it for sophisticated lawyers, well aware and exercised in the subtleties of lawmaking, or does it target the business community who are ready and willing to pay huge money for getting legal assistance? The assistance that is far from being perfect as regards the fundamental legal principles? Or is the draft code for millions of rank-and-file citizens who would rather like to use the code to protect their own rights and interests? I'm really afraid that all the draft codes are biased towards the first category of entities and not the last one. The code drafters, the lawmakers are striving refined legal constructions and concepts, thus forgetting the millions of rank-and-file citizens constituting the civil society of this country, who very often are in a very poor condition and in a very miserable life situations. They suffer from bribery because their officials are so corrupt. They have to deal with unfair business who are very often coupled with the corrupt officials. And these are the circumstances I would like to remind you of. Now, another point, which is related to the very structure of this part of the Civil Code. And here we start with the category of possession. And most probably here we deal not with the right of possession, but with possession itself. Possession can have a legal ground, or it may not have a legal ground. Until today, I haven't got a clear answer from any of the lawmakers as to what they themselves understand possession to be. What is their definition of possession? I've asked the question many times. I asked them, do you believe that there should be a discrimination between possession and holding, as in the Roman law, or do you stick to the institute of double possession, which, as you know, got recognized by the legislations of Germanic countries? I haven't got an answer to this question, not yet. My next question is related to the fact that the draft code has what I believe is overly and excessive classification of all kinds of property rights. An ordinary citizen cannot make it out. It's simply not possible. By the way, this also stands true for other parts of the renovated code, which have already come into force. At my university department, we often discuss these issues, and after many hours of discussion, we can still not come to an agreement as to what shall be the understanding or the essence of this or that legal concept. Which means that we always need to remember the target audience of the Civil Code, the audience the Civil Code is supposed to serve. I would now like to discuss several issues I have spent my whole life with. My graduation paper, which was presented to my university's professors in 1950, horribile dictu. And one of the central points in my paper was the question of the so-called possessory protection. Let me remind you that in the Soviet Civil Code of 1922, we had Article 170, and let me reproduce it the way I remember it. Back in those years, my memory was much better than it is today. But hopefully I shall make no mistake in reminding you. The tenant has the right of judicial protection against any infringer of his ownership, included, the owner included. With some amendments, this article was reproduced as Article 98 of the Civil Code. But under the opinion dominating back then, this regulation did not discuss the possessory protection issues. Let me remind you that back then in action was Article 5 of the Civil Procedure Code, which stated the principle of the activity of the court or domination of the court in the civil procedure. Now, this article has not been exactly killed, but it has been severely circumcised. So today, the supporters of possessory protection reproach its old-time defendants, including academician Veniamin and myself, even though they don't say my name directly. That's probably because that they don't condescend to mentioning my name at all. So anyway, one of the students of Professor Venediktov was a retrograde, and he did not accept the concept of possessory protection. But we must remember that our judgments were based upon Article 5 of the then Civil Procedure Code, and we believed that if we don't have competitiveness fixed by law, stated by law, and I believe that the legal mentality of the society of this country, competitiveness simply cannot be stated, because competitiveness per se means nothing else than a defenseless citizen is given over to a businessman who has heaps of money to use high-quality legal assistance, against which a rank-and-file citizen is absolutely helpless. Well, it's true. If we are ruling out this principle of judicial activity in civil procedure, which I believe to be a desperate mistake, it's like putting a cart in front of the horse. So the question arises, how shall we construct possessory protection? The draft code formulates this institute, shapes its institute with a lot of limitations and prerequisites, which allows the owner much less rights as compared to the old Article 170 of the old Civil Code. Given the principle of judicial activity in the civil legal procedure. The next point I would like to briefly raise is the the body of property rights. I'm not attaching any significance to whether or not we shall maintain the right of economic management or operational management, or whether they will be termed the right of operational management, both of them, because whichever way it turns out, each of these two rights is kind of stuffed with some stuffing, depending upon which legal entity it applies to, it is linked to. On the one hand, we may be talking of a Unitarian enterprise or a state-owned enterprise or an institution. So I don't think that's really important. But to a much greater extent, I am embarrassed by the experimental attempts by many institutes that have been shaped on the grounds of the legislation related to protecting and usage of natural resources. The attempts are being made to drag them over to civil legislation. This will inevitably generate competition with the civil code and the adjoining several other codes. In particular, I'm not only referring to the Code on Protection and Use of Natural Resources, but also the Code of Urban Development, the Housing Code, and many other codes.
And here we shouldn't artificially make legal structures more complicated so that everybody could see, oh, we're so cool, we're so great, we're so well educated, we're so careful about using normal legal experience. I don't like such phrases. We must stop thinking that abroad they have normal legal system and here it's abnormal. Are you crazy? but the latest events show us that our legal system in many cases is much more normal than those so-called normal legal systems that we admire so much. But I cannot, yes, I do understand that I sort of exhausted my time limit, and again, I don't really support those people who are in charge, and that's why I was not included in that work for a long time. But please, if those people didn't have such a system of friends club, if we could get different representatives of different schools involved, in this case our work regarding codification of civil legislation could be over, and it could be corresponding with much higher standards than now. Thank you for your attention. Thank you so much for your presentation. I do believe that you participate very dynamically in the work of our council. Yes, I do. And now you participated in our work, and you do it all the time. We receive wonderful but you usually bring me in through the back door. Well, but still, we bring you in, and we are really interested in your contribution. We want all our civil law schools to participate. By the way, the main person who wanted to provide more information for property rights is your student Anton Ivanov, a representative of St. Petersburg School of Law. You have to thank him, and we have to thank you as his teacher, as his mentor. I am not responsible for his stuff. He's been independent for a very long time, and he's in such high places. I never dream about such high places. So thank you, representatives of St. Petersburg School of Law. Thank you for your contribution, especially into property rights part. Maybe without your contribution, that part could look differently. But still, let's continue our discussion, and the next speaker is Tatiana Kuzmina. So she's deputy chairman of the Promsvязь Bank. Good afternoon. I'm grateful to the organizers for this opportunity to participate in this roundtable discussion, and I would like to express my respect to our scholars that started this complicated discussion, because I feel real respect. We do understand that we have fundamental sciences developed, but I'm a representative of very practical people, lawyers, and I would like to express my attitude to the draft law. I would like to speak as a practicing lawyer from banking community. I do agree that the changes of this law must be taken very carefully, with great attention. We must fine-tune all the systems, because it has already been mentioned here that we have to protect citizens, that we have some some sort of semi-wild business that must be tamed, but we must make the decision based on social protection and based on the fact that the government needs stable economic system. We all work in different companies. There are millions of citizens that work in different companies and they want business to be stable. And we must take into consideration the interests of the consumers, of the citizens. Also, we have to take into consideration the interests of business that brings stability into the economy of the country, makes citizens protected. But also, I would like to say that the systemic changes that are happening now, they require a major investment from also from big organizations, investment of effort, of labor resources, of cash, in order to make its activities correspond with the new legislation. And what's going on now? It brings a lack of stability, because the civil code doesn't depend on the researchers. It's passed part by part. And first we must get used to one change. Okay, we restructure everything, then another change is being introduced. It's a big problem even for major organizations. What can we say about small businesses, about medium-sized businesses, about simple citizens, entrepreneurs? That's why I would like to urge all of you. We would like the concept to be established first, and we would like the changes to fit one single concept. Now we see the changes in the civil code and the draft law on property rights. At the same time, on the 1st of March, we had the new changes introduced into the land legislation, and it's not harmonized. And we would like to conduct this work more conscientiously, and I believe that the government should first establish main concept and then make the changes fit that main concept, so that there is some kind of a support, so that we could have uniform logic. Now I am going to dwell a little bit on the draft law on property rights, but I would like to tell you about mortgage, this property right. As a representative of the banking community, I am looking at those amendments quite positively, because these amendments, they give the opportunity to introduce new tools such as independent mortgage. They provide the opportunity to fulfill obligations through the collateral of the right of construction. But at the same time, when we have the right of construction on the plot of land, in this case, if there is a desire to introduce some new approach, maybe that's just the introduction of the new edition, and also we could keep the right of lease and the right of construction existing at the same time. I'm in all for this approach, and I also would like to pay attention to the following fact. Now such property right as the right of personal use is going to be introduced, and I urge that you revise transitional provisions, because personal use is going to touch upon everybody's right. For example, there is the owner of the housing, the members of the family, they have the right of personal use. When certain provisions of the civil code get into force without registration. But as a lawyer of the bank, I can tell you that it could disrupt a mortgage market, because this way the provision is lost, because it says that when the real estate object is estranged, so the right of property use is terminated. So if we have the civil code, all the existing members of the family would get the right of personal use, but then after the object is estranged, whether it's sold, bought, and the buyer is not protected. The buyer could purchase the site which is populated by actual people, live people, and it would be impossible to get rid of them because there is a provision in the draft that personal use right could be terminated only at the consent of the parties. And unilaterally, the owner cannot terminate that right. But that's just some disadvantages. But in general, also I wanted to talk about something positive, to establish the seniority of mortgages. In this case, when we have a large number of creditors, and a large number of collateral holders, and in structuring of the debt, it would be right to give the right to the parties to establish such seniority. And in conclusion, I want to say that it's necessary to move forward. And of course, we need new tools. We must be progressive. But I urge us to be logical. Relying on one single concept. That's all I had. Thank you. Thank you, Tatiana. Next speaker is Maria Abramova from Gazprom Neft. And she is Director General of MNGC Gazprom Neft. Thank you so much. Thank you for this discussion. And our event is a roundtable discussion that provides for different opinions and different approaches. And today we have this unique opportunity to conduct this roundtable discussion, not just regarding changing of the civil code and giving new opportunities for business, but here we can look at these problems from the point of view of scholars, of practicing researchers, of professional legal community, of business, and also we can look at it from the point of view of the consumers of the civil code. And after we look at it through different angles, that's when we are going to have the tool and the institution that would allow us to solve all our problems and deal with all our tasks. And today is a very special day. So I am a representative of subsoil users, but at the same time I am a representative of Association of Corporate Lawyers that started participating very dynamically in the discussion which was mentioned here before me. But it's a remarkable day. It's a remarkable day because this day many years ago in 1704, Peter the Great had his first manifesto on mining. He said that our country was rich in subsoil and giving the right to the owners of the land to extract everything and pay the necessary duties to the state. And this is the very first document that gives us the opportunity to talk about the new subsoil institution. And talking about fuel industry, gas, oil, we represent the real sector. 90% of our sites are real estate sites. So we're talking about the rigs, plants, pipelines, lines, plots of land after we receive the license for subsoil use, and we must build the sites that are going to allow us to conduct our proper work, and that's why ours is one of the few companies that must apply these provisions first of all. And our business, with the 90% of real estate sites, are concerned about these provisions. What would I like to tell you if we discuss the special features? We have a major investment program, which is of capital program nature, that is going to be used for just fields, construction of plants, construction of fuel stations. Investment programs are very expensive. We make calculations about ARR, about NPV. Lawyers are very instrumental in working with us, and we look at the legislative basis that we could use in the period of implementation of certain projects, and we urge the lawmakers to leave the stability for us, because when we are planning the construction of the new oil refinery or renovation of a new manufacturing complex, we must understand that in the course of implementation our legal regulations will remain stable, and after receiving the permit for construction and after getting lots of assessment results, we don't have to run around and change the documents. Because for us it's a catastrophe. Catastrophe not just from the point of view of the law, but catastrophe from the point of view of the cash that we invest in development. But after it takes too long to build some site, or we failed to construct certain site which provides oil and gas, these are not just problems of business, these are consumers' problems. When we cannot get natural gas in the country, or we cannot fuel our car on the road. It's very live, it's very much alive, it's down to earth. And regarding legal innovations that we've been discussing here today, what is useful and what is not useful in the institutions that are suggested. First of all, Article 130 of the Civil Code, real estate right, and the new provisions regarding subsoil. Those people who were involved in research, they could write the whole doctorate on the subsoil plot of land being real estate or not real estate. Should it be regulated by civil law? Or maybe subsoil plot should remain in the history, which was established more than 300 years ago, when it was said, use subsoil but pay the government. But then it was said, use the subsoil, but you have to use administrative regulations. And those administrative regulations still exist here, and nobody is going to abolish it. And even if we write down in the civil code that subsoil plot became a real estate plot, is it going to have? But the subsoil law says that the subsoil plot is provided on the basis of the license, and the owner of that plot of land must fulfill lots of obligations apart from those that are established in licensing agreement. But that's only part of it. On the other hand, we understand that when we're talking about the plot of subsoil notion, it could help us to solve certain problems. For example, today subsoil use company is treating it as non-monetary. It's not on the balance. It's non-monetary, intangible, and all the capital spending we cannot tie it to this plot.
And if this subsoil plot becomes our real property, we could capitalize this property as part of our material or civil law turnover, not as some intangible asset. But this is only possible not just with the amendment of civil code. We cannot do that by saying that subsoil plot is property, but we need a change of the whole subsoil use legislation. I'm not ready for that, not yet. What if we take the Arctic shelf? What if we take the offshore deposits? What will be considered as property at exploitation stage of the Arctic shelf? What part of the subsoil resources are we talking about? This invites an integrated approach. If we are amending legislation, we need to do it in such a way that the whole civil turnover does not collapse and the consumer does not have to suffer from it. I would like to make another 2 points with regard to new provisions. And first of all, I would like to mention the servitude, the concept of servitude. We all remember from the Roman law what servitude is and when it can be applied. It's a wonderful institute that allows us the use of somebody else's belonging. The code enlarges the rate, expands the range of those servitudes, and where we cannot apply the right of property, we can try to apply the right of servitude. I would like to pay your special attention to 2 different servitudes, the mining servitude and the communal servitude, which allows, well, the utility servitude, which allows us to run some assets. Well, the mining servitude is a wonderful concept. It allows us to build over the deposit, to build over the deposits after we get the license. But the regulation is worded in such a way that neither me nor my practicing colleagues can understand how we can obtain the servitude. Do we obtain it together with the license? Where shall we apply for the right of servitude? How do we establish the boundaries of this mining servitude? What are we supposed to do with the other owners of the land under the surface of which we want to pump oil? There are some agricultural lands, there are some forested lands, there are some industrial lands under which our deposits are located. So this remains a pending issue for us. Another point, the utility lines, which are not only important for oil and gas, it's important for Wimbledon, for communications, for transmission lines. The utilities, or in Russian terminology, the communal servitude, can be used for different parties' interests, but most importantly, it has to be used for exploitation. This word has never been mentioned in the codes, in the new code, draft code, but it's about running the utilities line, not about site development, not about construction. The utility servitude seems to be the tool offered to us by the civil code to be able to build those utility lines and to use the power of the right of property which we already have. I would now like to refer to what Tatiana has said. The concept of the new civil law has been broadly discussed and adopted. The civil law studies are very close to myself. I've studied it a lot. I've been greatly involved with this subject. But the civil law science is okay in this country. But the problem is that our laws are not related to one another. The different parts of legislation in this country are unrelated. Why pass a civil code coming into force on the 1st of April? But after the right of property is adopted in its new wording, the civil code could be just thrown away into the waste paper basket. Why do we allow this to happen? That remains a pending issue. Thank you for your attention. Most unfortunately, we do have a lot of pending issues. That's unfortunate for all of us. Could we please proceed with our agenda? Well, if it were the Minister of Justice drafting the laws, we would have never had any such problems. Please speak into the microphone. Sorry, that's inaudible.
А меня всегда учили, начинайте с себя.
I've been always taught to start with my own self. I believe we really always have to start with our own selves, but then what we need is work together. We need to stand and work united. Then only we can obtain some real results. Then only we can take into consideration something that working alone you might never be able to even think of. So let us start with our own selves, but let us move to working together and stand united. That's actually what we are trying to do today. And having said this, I would like to grant the floor to Alexander Arseniev, Senior Vice President and General Counsel for YIT Construction Limited. Good afternoon, dear colleagues. I'm happy to see all of you here. I'm very glad to be part of this discussion. I'm just one of those rank-and-file citizens who is not ready to pay a lot of money for somebody interpreting the law for me. And I might come into contradiction with some of my colleagues who have already spoken with regard to the right of site development in the new civil code, in the draft civil code. So Anton has justly said that the legal practice in this country was largely based on covering the holes, like lease for purposes of construction, very often contradicts with its own essence, which is the purpose of construction. On the one hand, judicial practice has developed some very good approaches which dealt with it nicely, but this is not a systemic approach. So the day came when we had to decide what we can and should do, and we have already discussed the overlapping institute, and the right of site development is okay. It can and should exist. I actually quite like it, and that's what I'm going to talk about right now. My colleagues are giving me some dirty looks, as I can see. You know, I'm a corporate lawyer, and the business community can understand why I'm against this. All of us are a bit conservative. Any change for us, the corporate lawyers, is much worse than regular established practice. Even if the practice is not perfect, once we get accustomed to it, we know what to expect from it and how we can do our business. The amendments of property rights will entail other changes which are unclear and sometimes unpredictable. That's why we're apprehensive about it. That's why we are a little bit opposed even to adequate proposals. On the 19th of May, the State Duma had a hearing, and they were discussing our conservative approach, which largely relates to the transition period and the inception period. As my colleagues have said, when the new civil code is enforced in what relates to property rights, it should be linked to the industry legislation. It should become a systemic piece of legislation. Then probably we should not be in a hurry. We would rather like to have a slow inceptual phase. The new code should be phased in very gradually with no hurry, and that largely relates to the land code as well. My apprehension is rather about the new code being brought into force too rapidly, rather than the novels per se. Now, what regards the site development rights, which is highly relevant to my area of business, we believe that this is a very interesting right as compared to the right of lease that we have today. We should bear in mind that the right of lease now mostly applies to state-owned land. I'm a site developer. I'm a developer, so I'm rather interested in the right of developing a site as compared to the right to lease a site. My colleague has already said most of what I was planning to say. He has indicated the advantages of the right of development as compared to the right of lease. I don't have much to add. The right of development is much more interesting as compared to the right of lease. I might want to mention two other points which have been described and discussed in research literature. And one of them is the timeline, the deadline. Today, we sometimes get the right of development for 12 months, sometimes it's 6 months. The minimum should be 30 years, which is a much more powerful guarantee for the developer. With this regard, we were kind of surprised by the new provisions of the Civil Code in what concerns the right of development. It says that for the 10 years, the developer becomes the owner of the completed buildings. It's termed temporary possession or temporary right of ownership. And it's still ownership. So the provisions are based upon terminating of the right of development once this right fails to be paid for 2 times in a row. So the right of ownership becomes dependent upon payment or non-payment for land, to put it in simple words. We believe that under such circumstances, failure to regularly pay should be sanctioned in an ordinary, regular way, but it should not serve as termination of the right of development. It should not kill the right of development. We have already mentioned the land code and the civil code correlation. Professor Sukhanov has mentioned it already. I also believe that the civil code should stay in the civil code. The civil regulation should stay in the civil code because the land code is rather part of the public regulation. But now the land code contains a lot of civil law norms. But it has a lot to do to the public regulation. The systemic approach to all the civil law norms should be undertaken. It can all sit in the civil law. I believe that's more correct. It's all about the balance, the systemic organization of regulations, because we don't want systemic laws to contradict the civil code. Let me make another point. We have analyzed, my colleagues and myself have analyzed the right of development and its possible practical application. Really, we don't see any serious problems here. We have no apprehensions. All the issues we can see relate to the transitional period. People who already, entities who already are enjoying some rights may have some difficulties, but otherwise it's okay. We can transfer, we can convert to the new gauge, and we can protect the rights of the entities involved at the time when the new code comes into force. But again, it has to be brought into harmony with the land legislation. That's our greatest apprehension. That's it. Thank you for your attention. Thank you very much. We have just heard the response we were expecting to hear when we were drafting this section of the code. We were sure that the business community will welcome our amendments because they enhance their opportunities, they give them new opportunities. But it's true, we might want these amendments to be phased in very gradually, step by step, without disrupting the existing relationships. Because the property we are talking about are used for long terms of time, like land plots and completed buildings. We have invited our foreign colleagues to share their experience of legal regulation, and we have our colleagues from Germany with us. I'm sure it will be very useful for all of us to enjoy our guests' approach to regulating the relations as they are legislatively treated in the Republic of Germany. We have agreed that our German colleagues speak not as per the agenda. We shall first have the presentation of Dr. Janssen, and then we shall have the presentation by Dr. Marx. So, Dr. Günther Janssen, the floor is yours. You are welcome. Ladies and gentlemen, good afternoon is all I can say in Russian. But I hope Mr. Marx, my colleague Mr. Marx and myself are very glad to demonstrate to you some of the facets of the German land law. We are not going to share some unshakable truths. In Germany, we have had times of war and times of peace, and we have learned a lot from those times and from those changes. There still are a lot of people who would like to have some new changes. Once you have 3 lawyers, you have 4 opinions, but you have to live with that. We are now living through some very difficult times. And again we ask ourselves the question, where shall we invest? How do we guarantee the loans? How can we secure flows of goods and commodities? These are usual questions to ask in difficult times. Normally, collaterals are plots of land, and the property crisis in Europe and in the world proves that once again. Property prices are growing. Land prices are growing as well. Lease rates are growing too. And that, of course, makes life very difficult for SMBs and agriculture and many other sectors. Land is an attractive asset because it can be sold and resold. It never goes away as a marketable asset. It will always be well priced. It will always be in demand, but something can always go wrong. The world is not perfect. If somebody has a lot of money, this somebody will attract bees and flies like honey attracts them. If things go wrong, they can get really wrong, and this stands very true for plots of land. So the task is, of course, to secure the situation and protect the rights. 2 solutions are always possible. Let me draw a classical example. Entity A sells a plot of land to B, and originally it belongs to entity C. If we follow the Roman law, transferable is only the right you own. If you are a holder of a right, you can transfer it. And then let's imagine we have a buyer. The buyer pays, and then he's in a very poor condition. Of course, the buyer can file a claim against the seller, but whether or not this claim can be pursued, we do not know. Perhaps the money is already sitting somewhere offshore, and the seller is already sunbathing in California. So the buyer, of course, is at a great disadvantage under these circumstances. Now let me offer you the second option. The second option is to legally protect the buyer. There will be certain disadvantage to the seller in this case, because the situation will involve the seller. The German law of 100 years ago was persistently taking the side of the second option to secure good business environment. We have always said that we want the buyers to trust the market, and we want the seller to be able to assign their rights. They should be protected from some other change in 1 year some fake documents come out in a year's time, according to which the rate can be identified as null and void.
Well, such forged documents is nothing new, and the forging of titles, well, that was quite flourishing in the Middle Ages. That was a flourishing business, and that's why the mechanisms, protection mechanisms emerged at that time. And when people started writing, so they started writing forged documents. There are about 200 documents signed by Charles the Great. They're circulating in the world, and about 2/3 of them are forged. And the idea is, on the one hand, to create legal guarantees, on the other hand, to provide for the best possible business turnover. And here, in the course of more than 100 years, we really use the advantages provided by the German land register. And in the law of land, well, this is quite important, and it's necessary to be included in the land registry. It's not just a notification, but if there is nothing in the registry, that means there is no title. That means there is no purchase. Secondly, this is the rule when the buyer is always right. If there is an entry, it's interpreted for the benefit of the buyer. There is also the principle of consent. What's written in the land registry is something that the party agrees to put there. There is a legality principle, and not everything is included there, but the agency is actually checking whether it's the right kind of entry. Also, there is a priority principle, and the very first entry is the most important, and everything that's written there later is not going to be recognized, and further entries could be conducted only with introducing special corrections into the previous entry. And what's written there is the day, the hour, and if you look into the land registry and you can see that certain rights are reflected there, you must make one step further. You must find out whether some other applications are there, because as a notary you might otherwise have some bad consequences if those changes are introduced later. Also, there is a Russian saying that you must trust but verify, and we have the same kind of saying. So we must have everything notarized, and also this way you get certain degree of independence. And also there are some exceptions, and there are some strange people among the notaries also, but as a rule, and it's all done also, if it's necessary, you can get the judge involved, and also you can get to the main land court. In this case, you are going to face 3 judges, and in rare cases, you can get to the federal level. So this is quite a tight network. Regarding formal issues, well, before I give the floor to my colleague, I am going to say a few words about the following, that the boundaries, well, from the time of Napoleon, before he started losing battles, he was not really financially wise, and he wanted just to have the size of the plots of land. And the Prussian kings decided to charge taxes the same way. They had no money, and they decided to do it the same way Napoleon was doing. And now it's still, this system is still there. Now everything is in electronic format. Okay, so now we have number 1, where we can see all the property relations, who is doing what, using this or that type of contract. And also they discuss the credits, the loans, mortgages. And the difference is that the mortgage has 2 categories. That have certain guarantees, and with time just the rate remains the same. And well, there are some rules regarding just security for the credit, and finally now I would like to refer to Mr. Marx. Because here we have the right of use, and Mr. Marx, you're much better expert in this than me. You have the floor. Distinguished colleagues, it was of great interest for me to listen to you and hear your ideas about changes in the civil code that, from my point of view, are quite large-scale changes. First of all, they are connected with property rights. I don't understand all the changes you are planning, but I can see that those are large-scale changes. And right here, in my understanding, I take into consideration the legal procedure that formed my professional personality, and you look into your system. In Germany, everything which is on the plot of land is connected with this plot of land and belongs to the owner of the plot of land, and this is the original position. You own this thing. This is something which is the most important in our civil law. And it seems to me that the right to plots of land, well, it's a highly important factor in the economy because this right provides for certain volumes of investment, guarantees the readiness of the investors to invest the money, but also readiness of the owners to take care of the house, take care of the plot of land, because they're connected. And this stimulation is evolving because of private property. And in Germany, we still have exceptions and special property rights, and they are described in the law quite clearly. And because of that, it's highly important when you compile the contracts, when you are discussing the property rights, you must get very experienced lawyers involved that are going to provide neutral consultations. Notaries do that in Germany. The notary must compile the contract in such a way that this contract is registered in the land register. And first, as Mr. Janssen said, further they choose some formal issues, and then the land registry agency is doing it. And And that's why the notary must and is responsible for the deal to be actually done in accordance with all the rules, because his activities are going to be verified later. And all those real estate deals, they could be conducted differently. For example, there is the law that we call so it's inheritance construction rights, and the person may provide to the third party the right to own the building on the plot of land. And to own means to build independently or purchase. And this law provides very detailed explanations how such plot of land is to be used. In particular, there is certain interest that should be paid to the owner at the time of construction. Also, there is certain wording what is to be done when the contract between those two persons is going to expire, and so on. It's highly important for Germany in particular, where the plots of land have their owners for whom it's very difficult to sell their plots of land. For example, it's very difficult for German churches. And there are also other aspects when the plots of land are always connected with the buildings situated on it. For example, that's homeowners law. I'm not going to tell you that in detail, but the idea is that the building could be divided into different apartments, and the owners of the apartments are going to have joint use of the plot of land, and also for the main walls and constructions of the building. And also for all the cabling in the building or heating system. This is the violation of the principle that I mentioned in the beginning. I believe that there are similar rules in Russia. And the rest of it, well, in Germany we also have such a notion as servitude, but in the system of well, we're talking about the use of the plot of land in certain relationship. So it's not 100% assignment of rights, but only participation in certain relations. For example, somebody in this plot of land is doing something, and what could be, well, tolerated. For example, it could be tolerated that the neighbor has some kind of a device which is has bad smell and makes his environment difficult to exist in, and it's possible to provide such circumstances as the road being put through this territory, which is necessary. Also, right-of-way use. Some plot is not filled with the buildings completely, and so there could be 1.5 meters right and left from the gas pipeline. And if it's so, that means that the rest of it is not under servitudes. And also, it's possible to establish the windmill, but here we're talking only about the plot of land which is described in the contract. And finally, we have the right not to. So that's general. Well, it could be used. Well, it could be applied for general use. Well, this type of use also is going to end with the death of the right holder. So this consolidation, and that's how German law is dealing with their property rights. And also in fall 1990 in Germany we had very serious changes in the property laws, and when I listened to you regarding this right, I remember what was in German Democratic Republic, and in East Germany we had the same kind of right use. And the citizens had the right to build there, and they were owners. After the reunification of Germany, there were about well, after 1990, in the East, in East Germany, they had two tasks. So that's introduction of a legal mechanism and the introduction of the market relations connected with the fact that the sector of people's property was privatized, and I believe that it was a highly important moment. And now in Germany, the right of the law of East Germany had to be somehow fit into the existing system of West Germany, and it was written in the code that independent owner doesn't distinguish between the building and the plot of land. And in 1990 and till 1994, that was the premise. And finally, the law was compiled that allowed to combine the plot and the building just in one place. Today, this process is over, and 25 years afterwards, well, there is no contradiction. Why am I talking about it in such a detail? Because without that, legal relations in East Germany couldn't be possible to harmonize with West Germany. And those relations had to be somehow commonized. So the right of use, property rights, real estate, plots of land, land registry, land ownership, buildings ownership, all that was put into the special books, and it could be used. It could be used as collateral, could be purchased, could be sold. But I believe that it was just the right way to create those preconditions to harmonize East and West Germany laws. And such dual systems function only when 80 or 90% of the plots of land are in government use. Here we're going to encounter difficulties when we say what happens if ours is a private plot of land, although 90% is owned by a government party, and the legal system that you have, while there is a broad specter of government-owned property, but for me, there is nothing negative, and I believe that these two institutions, in theory, we could imagine, but practically, it's quite difficult.
Whether or not it will make sense to transfer the right to the building to the developer or to the private owner, to the eventual private owner. Who will the right be transferred to? If the term of my right to this asset expires, if the holder of the right sees no sense in continuing to use the asset or makes an offense against this right. For example, in East Germany, we had this case when compensation had to be paid to a building owner if something wrong was taking place, if something wrong was done. I understand that in your case, you are trying to shape the right of site development in a similar context. If we think in these categories, we have to make a discrimination between two different kinds of right. The right of lease may be more efficient here. It might be more of an incentive as compared to the right of development. I believe there should be a separation between the two. I don't think they should be mixed up in a saucepan to make some one dish. And in this context, I do not understand how you see the functioning, the application of the right of lease. I have tried to describe the way we can use them. We use the registry, and for that, for the registration, I don't need a notary. I only have to wait for some time for my rights to come into force. After this new entry is made in the registry. Otherwise, I have a constellation of the right of property and the right of lease, and it's difficult to sort this out. The right of lease or the right of tenancy should be implemented, if ever, very fast. If I lease something, it's entered in the registry, it's confirmed by the notary, and off we go. In Germany, we have 21 million agreements. We have 80 million people in the country. Our citizens are very mobile. They move from one place to another. They buy and sell apartments. They rent out and lease apartments. And it all changes very quickly. So the local cadastre services function as special divisions of the lower courts. They could have flooded with work if they had to introduce all those changes. Also, we have a lot of small garden plots. They are really small, where people come for leisure, to grow their flowers and dig in the ground. If I bring this to become part of property right, then the amount of work greatly increases again. I can only transfer right of property so easily because that's prescribed by the law. And there is always the notary who will check the land cadastre and who will check what happens after the agreement expires. I would like I think that a certain collateral should be used, and there should be made no confusion. Don't be tempted by a intermediary way. There is no golden medium. That's it, and thank you for your attention. Thank you very much. Sorry, the question was inaudible. Professor Suhanov, you have this problem of a plot of land which has nothing built upon it. In my country, this is regulated by the notary. There are certain obligations, and the encumbrances are also accommodated. We need to accommodate. We always accommodate both parties' opinion with regard to the plot and the building sitting on it. Do we have any questions from the audience? If we don't, do we have any more presenters? Do we have any comments? Anybody willing to speak? Unfortunately, one of our planned presenter has not made it here to the session, and anybody can take the floor if willing to do so. Alexander Lvovich, would you like to speak? Thank you. I'm really willing to say a couple of words. Just a few words, really. I could have remain silent because lots of things have become clear after this discussion. In fact, the concept that is the basis for the part of the civil code under discussion is acceptable. There is no serious objections to setting up limited rights of property. Since the draft was submitted to the Duma, 3 years have passed, and during these 3 years, not in the literature, nor during the discussions or hearings, any significant objections have been voiced. Yes, we can argue about which kind of property shall be or is protected, but nothing will change after this new edition of the code is adopted. But what is the problem today? The answer has been already given in the Duma, it has been given in this audience, and it has been given at the conference of corporate lawyers, of a recent conference of corporate lawyers. But the question is, how can we convert from one code to the new, from the old code to the new one within reasonable time and with minimum losses. This task is not much easier than creating the basic text of law on property rights. The issue of correlation with the land code is a prominent issue. But even a long time ago, it was clear to us that the land code should be turned into an administrative procedure code. All the norms can be easily transplanted to the new code, and everything remains clear for everybody. Well, the lawmakers understood that 3 years ago, but 3 years have passed, and the land code was amended, and it still is being amended. So this requires some more work and some more attention. Another point, not really related to this section of the code. The point is regulating the land use and the lawmaking with regard to subsurface-related rights. Dr. Ivanov drafted the subsurface resources use law about 10 years ago. That was a very clearly composed and well-organized draft law. But somebody did not like it, and it was put into a faraway drawer, as the Russian saying goes. So then another concept was drafted, and it was drafted in a very hurried way, and this other newly drafted concept faded away and was left to sit somewhere and forgotten. So when we deal with property rights, we probably want some serious analysis with regard to subsurface resources used. My third point is next. Finally, we are hearing lawyers involved in business. We have finally heard them saying how bad Russian legislation is. It only took a very short time to lose any systemic approach at all. A whole group of systemic codes could be used further on for systemic purposes, but instead they were turned into a chaos. Together with Jura, I can remember the 1920s. They took 15 years to kill the old code. We have managed to do it much faster. Nobody is thinking about rearranging it to some point of order. Personal property rights is being given some priority now. Everybody is saying that it's so good to protect the holder of rights. But why is nobody saying that the owner has to be protected? The right of land property is suffering greatly these days, but it all started with very nice things. The APEC law, the APEC construction law, then the Olympic construction law. Now we have the draft law on integrated development of territories. And trust me, it's the Ministry of Economic Development that's behind this last draft law, but it was introduced by 5 deputies on a personal basis. And this draft law says that the land can be exempted by those who would like to develop it. They are supposed to carry out the whole process themselves. They are supposed to pay, and the state just stands aside. If this is the way we are going to protect the right of property, we just don't need any rights at all. Thank you. Do we have any more questions or comments? I've been asked to briefly summarize and respond to the presentations and comments made so far. I have no objections to Professor Sukhanov because I fully support his opinion in what concerns the ways we should further develop the right of property in this country. So I shall abstain from any further comments in this regard. Now, what concerns Professor Tolstoy, who was my tutor back at the university, I would like to speak as critically as he did. So I don't believe nobody explained to him what we were planning to do with the concept of possession. We were not doing anything about it. We let it stay as it is in the new civil code. We are not introducing any double possession. We are not introducing usufruct. It all stays the way it is now. And we have spent quite a few years trying to explain what are these concepts as of today. I can reiterate the explanation now, but this would be bad manners for me to do so in the presence of Professor Tolstoy. So this was my first point so far. With regard to his criticism of the concept of possession. Now, what concerns the fracturized set of property rights, I believe that better more than less. It's better to have a choice than to have no choice. If the land code of 2001 had not killed the property rights from the code of 1994, which was only enacted 6 months before that, we could have went on with the set of the property rights as per the code of 1994. But most unfortunately, the land code had left us no choice. And I would like to draw everybody's attention to the fact that we still have no such choice. We cannot help but amend the current legislation, because time will come when we shall say the right of infinite and indefinite use is now terminated and no compensation is available. Either we have to abolish these provisions we need to say that the right of ownership stays with everybody, not only with religious organizations and institutions. This time will come, and we shall have to tackle this problem. Now, talking about a code worded in a clear and simple way, I would like to remind everybody a well-known phrase about the thin pages of the codes drafted for workers and peasants in the 1910s. But that was the time when everybody was expecting rights to die out very soon. We have not yet got anywhere close to that stage, and I hope we never get there. But anyway, unfortunately, making unnecessary complications to legal concepts is something that should not be done. But we should not either be guided by people who have total disrespect to the legislation of this country. So I would rather try to strike a balance between the two approaches, especially given that well-developed norms of the civil code is one of the attributes of civil turnover. This would be beyond the point. Representatives of the business community have already discussed
well, I do agree, and it could be great if we had everything arranged in a systematic way and we could come to an agreement, but because of the legislative process, I believe that it's impossible. And it seems to me that it's important for business, and we must have the ministries and agencies work with the draft law, and we must stop this crazy practice when every local little inhabitant starts writing the law about his tiny village. The process must be left in the hands of one user. And without that, we're going to encounter all those terrible difficulties. And Alexandrovich was talking about all that, but I believe that we know who was doing it, and we know why we received it all. And finally, it seems to me that German experience, in particular, I listened about land relations in East Germany, and so when they decided to have the principle of this uniform site, well, and we discussed the concepts and the draft civil code, well, we decided not to risk, we decided not to touch the situation, although we had the suggestions that we could connect the plot of land with what is situated on this plot of land. But we imagined objections that we were going to encounter, and we realized that the code would be just stuck in the parliament, and that's why maybe we should accept what they have in the State Duma, and then we could outline a very separate draft law and slowly, step by step, without any punitive measures, without tough timelines, we could very slowly combine land ownership with the ownership and what's on the land. Unfortunately, the land code that declared the necessary nature of this kind of site created regulations that actually strengthened differentiation. And now this process is going even further. And how to get out of it? Well, I don't know. Difficult. And my last comment. Actually, the guarantees of the real estate market must be government guarantees to compensate for the damages of the party whose right was in the register, and the party lost that right. But I believe that we are even further from that. Then we were in 2001 when the land code was adopted. And the Ministry of Finance doesn't want to be liable for anything. I believe that the system of registration is not going to be supplemented by government guarantees. And all the risks connected that your real estate could be stolen, could be taken from you, all those risks are on individuals. And that's going to be like that for a long time. I don't see any way out in the nearest future. But this is our real life that we have taken into consideration. Thank you. May I make a comment? Well, I agree that the more legal institutions we have, the better for business. In this case, as it seems to us, leaving the lease is not going to be harmful. Let them compete, because most probably, parallel fashion could be favorable. Follow up. I believe when we have application of our rules, unfortunately, a lot of land is now in government property, and it's highly important if we introduce new institutions that we are ready to use, and the lawmakers provide this opportunity, and it's the right way to use it by the government officials, by people who are working for them, because otherwise those institutions won't be used for practice. Well, this is the issue. Lease. Who is going to get rid of the lease? Nobody is going to get rid of it. Let it stay. We are going to get rid of everything which is going to be an obstacle for the lease in the future. It's going to stay. Don't be afraid. Secondly, along with the lease, the property rights would be provided. Who is going to suffer? Nobody is going to suffer. And the most important, we have to work with transitional provisions very conscientiously, because so that nobody suffers. So this is the main task. And we are going to work at it. And when we outline it, when we solve this problem, I believe that it's going to be introduced to the State Duma, it's going to be passed, and nobody is going to suffer. And everybody is going to gain a lot. Why? Because the main task is to lessen this dependence on the government officials, because the lease is in the hands of government officials. But what we are suggesting, they really make this dependence weaker. We want to make this administrative pressure much weaker. If you agree, you must support us. Okay, let's come to an agreement to move together. I believe that it's good when draft law is in the hands of people who are not directly interested in those constructions. First, scholars. Second, judges. They're also not interested. And government officials especially, well, they're really interested because they have constant contacts with those people who own land. This dependency must be weaker. I have a question. So, what is the timeline to outline those transitional provisions? Because I'm older than all of you, and a little bit. Am I going to live and see? And secondly, Anton, you said that you were involved with the notion of ownership, and because you left it intact, you believe that you're going to work with it in the future. So what is the time frame for you? What are you going to include? Well, I believe that he's going to ask for your advice. Well, I believe that I can have good income all for the rest of my life if I deal with this issue. It's a job for life. Well, we have lawyers present here. We must solve one problem. We have private law and civil law in the center of private law, and private law for many years, 20 plus years, and private law is evolving, I would say, quite gradually. Because we have the research center of private law, which is working. This is a good group of scholars, and now suddenly it became stronger. It became stronger because of some former judges of the Supreme Commercial Court, and this is a wonderful group. So let it continue its work. We have to think about possible financial help so that these researchers continue their work. And secondly,
there is a Presidential Council for private law and property law, and Professor and myself have invented this council. We wanted some body under the president that could allow us, with the support of the private law center and the civil law studies, to feel the pulse of the private law legislation, so that we could constantly keep in touch with the president with this regard and keep them permanently informed. The center has been operational since 1999. There is a regulation on this center approved by the president, and after this regulation, all the government agencies proposing any civil law drafts must submit their drafts for our consideration and scientific review. And this council under the president is the most operational of all such councils. It meets at least once a month, sometimes more often than that. And we have been operating in this way since 1999. You can imagine the progress we have made. At each meeting, we consider 10 to 15 draft laws, mostly submitted from various ministries and agencies. And every time we review the drafts, we get sadder and sadder, because the level of lawmaking in the ministries is getting so sadly worse and worse. We get texts with spelling mistakes, to say nothing of the legal quality. The decreasing quality of legal education and the reliability of the graduation papers are the reason for poorly educated and trained professionals. Perhaps they do gain the knowledge and skills they miss at graduation, but this is really becoming a serious issue. And the solution, or the solutions offered, are rather petty, non-professional, and poorly deliberated. So we have to contribute a huge effort to do something about all this situation. So we are not liked. People try to circumvent us, to jump over our heads, but to no avail, because we are pursuing our goals and we are proceeding with our work. I believe that something similar should be done with relation to civil law. Unfortunately, we don't have anything like this. We have the Legislatory Institute under the government of the Federation. This might be a tool to further improve the public law. Here we are discussing we have a lot of discussion with regard to land, which is largely relevant to public law. Land and the subsurface resources and forest and bodies of water are all subject to public law. So there are lots of public services involved in dealing with all those assets and properties. Public law regulation is largely required here. Who is supposed to watch over the status of this public regulation? There is no agency who is charged with this task. It could have been done by the Ministry of Justice, but they have to work with the Ministry of Economic Development and the industries. And those functions require a lot of efforts. That's probably why a lot of the draft laws come to us so raw and so poorly drafted. We might want to introduce an intermediary link to do all the legal technicalities. They need somebody responsible of this stage of legal work, of lawmaking. So far we don't have this stage with regard to public law, and this is really badly needed. So I'm appealing to the legal community to approve this idea. Let us all take some measures for such a body to be created, for such centers to come into existence. then perhaps it will be easier for us to bring together and to interface the public and the private law. Without this interface, we shall not be able to improve the legislation, because there are no areas that can be regulated by public law or by private law only. Regulation is always an integrated process, and that is very clearly visible from the proposed draft laws. We have heard these very important considerations, which are very much part of our common mentality. Unfortunately, we are undermanned, we are understaffed. We don't have any true experts, as you justly said yesterday, true experts of the administrative right of the market economy. Today you have not mentioned this concept. Well, I just didn't get that far. But you are exactly right. We have no scientific justification for administrative law application in market economy. Recently, I talked to our guest, Dirk Miro, who is the head of the Legal Cooperation International Fund. Recently, we had a very interesting discussion with him, and I am going to tell you about it, in spite of the fact that we have run out of time. Very often, I speak to different audiences, and every time I ask the following question: what is the society we are living in today? Back in the Soviet time, we knew what was our society. We know that there was the slavery-based society, there was the feudal society, there was the capitalist society. What is the society now? What would be your definition? There is no definition. Or is there no society? I'm saying that, okay, a transition society, transition type society. How long will the transition take? When will it be over? Is it really a transitional period, or if there is a transition, it's a transition from where to where? Dirk Miro once told me that in Germany, nobody says that Germany is living under capitalism. So what is the regime in Germany? It's the social market economy, or socially focused market economy. In Germany, they just say social market economy, right? So if you analyze the Russian constitution, you will see that the Russian constitution is a constitution of a state based on a social market economy. So let us remember this, and let us work towards it. We want a market economy, but it should be socially focused, even though nobody knows what it really means. Life will give us the answer. Life will make us answer all the asked questions. Remember the presidential decrees. If you remember what they say, that is social economy or socially oriented economy. So we do have some elements thereof. And if you analyze the Russian constitution attentively, it's really focused that way. So, colleagues, lawyers, we all are responsible for the citizens of the country to know what is the society they live in. Let us raise their awareness. I have something to add. I think it's very important that all these documents are operational and working not only during the election campaigns, but after the election campaigns as well. There are regular meetings taking place with the purpose of evaluating the progress in implementing the decrees and instructions. And that means we do have a social mechanism. Thanks, everybody. Thanks once again. Thank you for your participation in this panel discussion. I've nearly used the word fraction, but I haven't.